I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are knocking on the door of compilation 144. And for this particular compilation, we have a sovereign citizen that we had covered in the past that recently was back in court. So we're going to share her first two appearances and add her most recent appearance to this compilation as well. And before I give you the rundown of the judge's courtroom she was in and the bonus judge that we're going to add to this compilation, let me let you know that there will be chapters added for your convenience. Also, there will be commentary left from the previous proceedings in this particular compilation. Don't forget to like, comment, share, and subscribe. And if you guys get a chance, please go and check our community page. We have a poll up. We're trying to decide if we're going to add more traffic stops to these compilations because I have access to sovereign citizen traffic stops. So please go in and weigh on that. Your advice, or I should say your opinion, is appreciated and important to us. And now with that being said, let me give you the rundown of the judges' courtrooms that we will be in on today. First, we will be in the courtroom for Miss Alicia Martini. That's who was back in court recently. We will first be in the courtroom for her first appearance in the court of Judge Sam Meyer. Her second appearance is in the courtroom of Judge, I don't know why I always forget his name, Jacob Stillwell. And her third appearance also is in the courtroom of Judge Jacob Stillwell. All of these are out of the state of Washington, Thurston County District Court. Our last proceeding, our bonus proceeding, is going to be coming out of the state of Michigan, and that is going to be in the courtroom of Magistrate Laura Echartea. And listen, guys, we are knocking down these compilations. We're getting ready to hopefully add these traffic stops to these compilations and get more of some footage that we haven't had when it comes to some of the regular court proceedings of sovereign citizens past, present, and eventually future. So it's going to be an exciting time for 2026. And listen, let me get ready to get out of the way so you can go ahead and enjoy number 144.
The Thurston County Correctional Facility. What's your name up there?
Alicia Martini.
And then I don't see Ms. Millar up there. Ms. Moore, are you covering that one from here?
Your Honor, Ms. Martini is pro se.
Give me just a minute, ma'am. Okay. So it's on the case ending in 853. Pre-trial.
Your Honor, on 6/6 of this year.
Just wait, ma'am. Just give me a minute, please, ma'am. So on the new case, Ms. Moore, 25 DV 1023. She's here on a warrant return on that case. She's held on bail on the other case. This is the arraignment on the protection order case. But it looks like they've already set confirmation and trial dates without her being arraigned. How did that happen?
I have no information, Your Honor. Ms. Martini has declined counsel. She wishes to represent herself.
Okay, so hang on just a minute. Yeah. No trial dates are set on that. On the protection order case, the trial dates are on the trial dates are on the DWLS and the third and operating a motor vehicle with ignition interlock. There's no trial date set on the DV case. Okay, so ma'am, your name is Alicia Martini?
Yes, sir.
And then you're here on a couple of things. You have that are unrelated. You have some driving offense, driving with license suspended in the third degree, as well as operating a motor vehicle with ignition interlock, without an ignition interlock when it's previously ordered. And then
my original DUI was thrown out.
Just let me, ma'am, let me finish. I'm just telling you what your charges are now. I don't know about prior charges. That's a charge. You may have a defense to it. I'm just saying that's what you're charged with right now. You're also charged with one count of violation of a protection order. And then you haven't been arraigned on that. We're gonna do that at some point today. So on the violation of a no contact order, and again, these are just allegations, that's a gross misdemeanor. That carries with it a maximum of 364 days in jail and a $5,000 fine. So anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney. If you can't afford an attorney, I can appoint an attorney to represent you at little or no cost. You have the right to a trial by jury in the county where the crime is alleged to have been committed. You have the right to hear and question witnesses called by the prosecution. You also have the right to call witnesses on your own behalf, and I can require the attendance of your witnesses through the use of subpoena. You're presumed to be not guilty of the crime charge. You cannot be found guilty unless the prosecution proves the elements of the crime beyond a reasonable doubt at trial, or unless you enter a plea of guilty. You have the right to remain silent. You're not required to testify against yourself. At the same time, you do have the right to testify on your own behalf if you choose to do so. And finally, if you take this matter to trial and lose or are convicted, you would have the right to appeal your court. Do you understand all those rights?
Yes, Your Honor.
Okay. I want to go back to that first right, and that's the right to an attorney. That's an important, and if you can't afford one, as I said, I can appoint one to represent you. And I'm fully prepared to appoint an attorney to represent you in this case that you're in front of me here right now. And most people, pretty much everyone else, when they get the opportunity to have an attorney appointed to represent them, they jump at that chance. But I'm told that you're not as inclined to take advantage of that offer.
Yeah, I'm a sovereign citizen, Your Honor.
Okay. So sovereign citizens can take advantage of an attorney as well.
It's okay, I'm pro se.
Okay. Have you ever why is this jabs taking so long? Listen, that's one thing. I don't know. I have to keep doing this. So, ma'am, you have you ever represented yourself before?
Yes.
Okay. Have you ever gone through jury trial?
No. I never had to.
Okay. Have you ever been to law school?
Nope, never had to. They got dropped.
And you're not a lawyer?
Nope.
Okay.
I'm a sovereign citizen. My charges got dropped.
Okay, but I'm not sure about these cases, but you understand
they were
the
already
prosecuting.
Okay, these charges were already NFC'd last time I was here in jail.
Okay, so ma'am, you understand the prosecutor in these cases are lawyers. They've been to law school. They understand the rules of evidence, rules of criminal procedures, things you may not be trained on. So you're operating at a pretty serious disadvantage. Do you understand that?
Yes, Your Honor.
And knowing all that, you still wish to represent yourself at this time?
Of course.
Okay. Which case? Is that her case? Okay. Oh, I see. That's it. Right. So it's 853. Yeah, the pre-trial, and then there's 20V to it. Okay, and then the 1017. Is that set for trial? Is she being held on that? Oh, I see. That's the only. Was that the only one she's being held on? So you actually have three cases. One was just added. That's why there was a little bit of a confusion. You're charged with, on the case 25 DV 1017. This computer, man. She's being held on that. Okay, bail's set on that. And then it looks like, I'm not sure I agree with that. Yeah, the new one has $5,000 warrant, but I don't see any bail set on the old one. Keep refreshing. Okay, so ma'am, you have a court date set on the DWLS and the operation of motor vehicle without an ignition interlock. You have trial confirmation on January 7th. You have trials on January 12th and 13th on the assault in the 4th degree. On the new charge, which is protection order violation, a plea of not guilty will be entered. This matter will get set for a pretrial. We can do that also on, and you're not being held on this is a warrant return on the new charge, the protection order violation. There's $5,000 bond on that. I don't, a bail on that, or warrants. I'm going to hear from the state on conditions of release on that, and then I'll hear from, I'll come back to you, ma'am.
Okay.
Mr. Libby?
Your Honor, no objection to leaving the conditions that were previously imposed as is. That's the $5,000 bail that was set on December 1st for this new matter, 1023, as well as the previous conditions that were imposed at the prelim all the way back in October 27th.
Which are no criminal law violations, comply with the no contact order?
Yes, Your Honor. Sorry. Yes.
Okay, so on the case ending in 10/17, there's going to be no changes in conditions of release on the case, and then your next court date is January 7th, I think. On the case with the operating motor vehicle without an ignition interlock and the driving with license suspended in the 3rd, that'll no change in those conditions also. There'll be $1,000 bail set in that case. In the new case where we are setting where you're getting arraigned on, which is case ending in 10/23. I'm not going to hold you on that case either. All prior conditions remain, which are don't have any criminal law violations, don't possess a firearm or other deadly weapon, comply with any existing no contact order. We'll set a pretrial. We'll do it earlier than that and back these up on the other one. We'll set a pretrial on Wednesday, December 17th. We'll set it right on the 1:30 calendar. Or actually, no, we'll set it earlier than that in case she makes bail. That's only $1,000 at 10 a.m. And that'll be it for today here. And then you can be taken back. Do you understand all that, ma'am? Yes.
Can I please fight for my own bail?
Can you
That's
what?
my right. Fight for a PR. That's my right.
That it is. And you that was.
And you said you were going to hear from me, and you didn't.
Okay. I can hear from you now. Because I'm not holding you on the new charge. They're only being charged on bail on one case, and that was the case that was decided by Commissioner Wool a day or two ago. So if you're asking me to reconsider or redo what he did, yes, you can do that.
Yes, Your Honor, please. Okay, so I've been held for a substantial amount of jail time on both of these charges now. They're both misdemeanors. Neither one is violent. The driving charge, like I said, I'm a sovereign citizen, so I have the right to travel. And also on 6/6/2025, that charge was vacated due to speedy trial rights violated. Because from 2019 to 2020, I never had a court date set because of COVID. So they vacated that charge on 6/6 of this year. I got a status case report from the Thurston County Clerk on 6/6 stating that that case was terminated.
Throw this thing out the window. Mr. Libby, what's this? Again, I do that from 2020. Ma'am, I don't see that case was dismissed. I'm looking through the docket now. Looks like you had an attorney for a while on this case.
Yeah, on 6/6 of this year, there was a case status report from the Thurston County Clerk stating that it was terminated or vacated. Terminated. case terminated due to speedy trial rights, because if you notice from 2019 to somewhere late in 2020, there was never a court date set because of COVID.
Okay, so hang on just a minute, ma'am. Mr. Libby, you wanted to say something?
So I'm seeing there was a hearing on
6/6.
June
Yes.
6/6. I was present for that. I believe the state asked for a motion to continue. Mr. Pazderka objected. Trial was reset for the hearings were reset 1 week, and we entered an excluded period.
Right. And then she didn't appear for trial, and a warrant was issued on 6/23.
Yes, I'm seeing that as well. Yes.
So, ma'am, I'm not reading the docket the same way that you are.
Okay, maybe
you
the
were
date that I have is wrong, but it said case terminated. I got a case status report sometime in June, I believe.
Okay, and what my reading of the docket says, you were not here for confirmation on June 6th. The trial was going to be set for June 23rd. You were supposed to be there on June 23rd. You did not appear, and then a warrant was issued at that time. And I don't see anything. One thing that may have been canceled was your trial date was canceled once you missed your court date for a warrant.
No, it literally said case terminated.
Please don't. Okay, I don't see that, and I don't see that in the docket that I'm looking at.
Your Honor.
And so,
No, I'm asking to be released so I can get that information for you.
okay, go ahead.
Nothing, Your Honor. I'm just trying to clarify stuff.
We'll go ahead if you can. That would be great.
There doesn't, Mr.
If there's ever a case in need of clarification, this would be it.
There does appear to be a 2017 Superior Court matter that was vacated. I believe it was a Blake case.
I can help, Your Honor.
Oh, I see.
Here. Case 17, TAC 1, TAC 04338, TAC 0. I wonder if Ms. Martini is maybe getting that case mixed up. That was a Blake vacation.
No, I'm not.
Okay. So, ma'am.
It was case terminated, not vacated. Yes, I had a case vacated as well from the last time I was in prison, but this case was terminated. I'm just asking that I please be PR'd. These are not violent crimes. The victim was not the reporting party of the no contact order violation. I don't have any way to post bail or any way to even contact anybody right now, as the victim was my only person that I had in life, pretty much.
Right,
so
ma'am.
I'm just asking that I be please PR'd.
What I'm going to do here for today, ma'am, I'm going to set the protection order. The new protection order will be a pre-trial at on 10 a.m. on December 17th, and then on the what I will do is this, ma'am. I'll set this back on the calendar for only being held in bail on one case, and that's the DWLS third and the ignition interlock. And it's probably been around for quite some time, but now that you've given notice to the state of your wish to have bail reviewed, we'll set this over 24 hours tomorrow, and then we can check in to see whether this thing has actually been vacated or dismissed or what have you. And then we can reconvene tomorrow for a bail hearing on the DWLS in the third case. And then the other can be backed up to it. All right? Now,
Your Honor, one more thing. So is the defendant not being held on that new charge, that violation of protection order? There was bail imposed? Is that being...
No, that was, a warrant was issued in the amount of $5,000. She was picked up on the warrant. Now the warrant's been served. So now we go forward. Then I make a decision as to whether set bail or something like that. That's my reading of the docket.
My reading of the docket, Your Honor, is that there was a warrant FTA at December 1st, and Commissioner Wool imposed $5,000 bail on that new protection order violation.
Give me a minute. And that's the 1023 case, right?
Yes.
Oh, you did say, yeah, I did see, I see that now. didn't hear Rainer on that day. You know why it wasn't arraigned on that date?
I don't have any other notes, Your Honor, other than bail was imposed and arraignment was just set for today. I don't know why it was set for today.
I don't either. And that was the first, that was Monday?
Yes.
We'll just put all these on tomorrow. Do all these on tomorrow for conditions of release and settle that. You've taken way too much time on this right now. So ma'am, you could have conditions of release addressed on all these cases tomorrow at 1:30.
Okay.
And between now and then, I'd really think about your decision not to take advantage of an attorney. I think you're doing yourself a real disservice, if you want my frank opinion.
I'm a sovereign citizen, Your Honor. I trust in my own opinion.
I heard you. And I can't save you from yourself, but I'm just saying that, I'm just saying. So we'll all reconvene tomorrow to address conditions of release on all of these, so we can get all this sorted out. And you can be taken back, and yeah, the 5,000 will remain.
Honest on that one. So $5,000. All right, we'll set a review here, competency review hearing on Friday the 19th, Friday, December 19th. Scott. Direct set that to 1:30. Right. I've signed a JNS setting a review hearing for Friday the 19th and setting bail in the amount of $5,000.
Thank you, Your Honor.
Thank you. And I'm also signing the 1077. Or I already have. Okay. 230. Galen Rubel. Yeah. Okay. Good afternoon.
Good afternoon.
And your name?
Alicia Martini.
All right. And Ms. Martini, you are proceeding pro se, is that right?
Yes, sir.
Okay. Is that still your wish to move forward without an attorney?
Yes, sir.
All right, and I know you've had, I can just see from the docket notes on your cases, you've recently sort of gone through the colloquy with a judge about your decision to move forward without an attorney recently. I just want to make sure that's, you have the right to an attorney if you wish, and I know a judge has already walked you through that. I just want to make sure that's still your decision.
Yes.
Okay. All right. And you were here yesterday, is that right?
Yes.
Okay. And correct me if I'm wrong here, but I'm going to kind of summarize where I think we're at. So this is a review hearing for bail on 2 of the 3 matters. One is a protection order violation. Bail was set at the amount of $5,000. The other is driving with a suspended license, 3rd degree, and driving without an ignition interlock device. For that case, bail is set at $1,000, and you are not being held on the assault 4th degree domestic violence case. Is that
Yes,
your
Your Honor.
understanding? Okay. All right. And yesterday was the arraignment on the protection order violation case. And today was just to address bail. Is that right?
Yes, sir. Yes, sir.
All right. Okay. Well, so a change in release conditions does require new information, a change of circumstances, or sort of similar good cause. A judge has previously imposed those bail amounts. I'll let the prosecutor also weigh in, but I'll start with you, ma'am. What information can you give me about why a reduction in bail or personal recognizance release is appropriate here?
Can I have a breakout room with the prosecutor, please?
Well, I suppose if you're not represented by counsel, is that something that's up to you?
I'm not the attorney assigned to this case. I'm willing to speak with the defendant, but I don't know how much good could come of it. I'll just be quite honest.
Yeah, I mean, ma'am, one of the benefits of having an attorney is they're able to have those conversations. Mr. Libby here is assigned the jail calendar today, but he's not the prosecutor on your case. So it's unlikely that he'll be able to make any substantive decisions other than asking that, dates remain set.
It's okay.
Are you still wanting to speak with him?
Yes, sir.
It's up to you.
I mean, yeah.
Okay. So we can set up a breakout room. I'll take the private case while that's.
Your Honor, actually, I've spoken with Ms. Pritikin just now, who's the assigned DPA for, I believe, the 2 DV cases of the defendants. She's willing to speak with her right now. I think that might be a more productive use of time, actually.
Okay. All right. I think in order for that to happen, you said that was Ms. Pritikin?
Nicole Pritikin, yes, Your Honor.
I think she would have to sign into Zoom and then get a breakout room with the county jail. All right, so Ms. Martini, the assigned prosecutor on your case, someone named Nicole Pritikin, she is going to be signing into the Zoom hearing here, and then we'll put you in a breakout room together.
Okay.
All right. All right, I see you came off mute. Are you able to come off? All right, hi, Ms. Martini. Are you able to come off, activate your camera?
It does. It doesn't get to play it, do the video because my phone battery is too low.
Kind of hard to hear you. Were you saying your phone doesn't have video?
Hello?
Can you hear us okay?
Can you hear me, Your Honor?
We can. Doesn't sound like you can hear us though.
I'm sorry, I can't hear you.
Okay. All right.
Ms. Martini, we have been trying to reach her to give her discovery,
Okay.
and we held it at the office.
Okay.
She doesn't have her discovery as a problem.
Okay. And Miss Martini, are you still unable to hear us here?
Say that again?
All right. All right, Miss Martini, for today's hearing, I don't think this is going to work today. We're going to. She can't hear me.
What was that?
Here. Yeah. Can you let her know?
Option on here?
I don't think so. Can't hear that. Yeah, if you can let her know. Well, just let her know that we are aware that she can't hear us, so no need to respond. We're not addressing her directly. Ms. Pritikin, do you know when Speedy runs on this case?
I haven't looked. I'm sorry, Your Honor. She has two cases that are DV, and then another one's up for trial confirmation that's general misdemeanor.
Yeah.
And a backup. Oh, well, I guess one of the DV cases is the backup case.
Yeah, the backups were all set to each other. So I think there's actually 3 cases here.
Right.
Or
1017, 1023, and then the one ending 853.
Yeah. Well, let's see.
She was told back on December, she was told multiple times to go to the PAO office in building 2 to get discovery, and she never picked it up.
Okay.
For the 2 DV cases.
Okay. Yeah, and I saw that she, as of yesterday at least, is checking in with pretrial services. I know this was on for conditions.
I guess,
so she's doing that.
Just as of yesterday. We also mailed her letters to pick up discovery.
All right. So I think trying to figure out Speedy, because I would like to, she can just call in. If you want to send her a message that if she wants to call in on that new number.
And she does not have an attorney. I've spoken to her privately on a Zoom breakout. I think, we had a discussion with her about it.
Yeah. This is the first I've been on the bench for one of her hearings. Does she?
I think there needs to be more discussion about what direction she's going in. She has not had a discussion with me about resolutions, which needs to happen.
So let's wait and see if she calls back. Better reception.
Yeah, she was supposed to, back on December 4th, the court ordered her to pick up discovery at the courthouse and said that discovery would be held at the main courthouse until the 22nd. And she was supposed to sign that she's picked it up, and that didn't happen.
All right. Ms. Martini, can you hear us now?
Yes, can you hear me?
All right. Yes. Okay, we can. So Ms. Martini, from here on out, you're going to have to come in person, because if we can't see you, we have connection issues. We're not able to have these hearings.
Yeah. Okay.
Right? Okay. All right. So Ms. Martini, we're here for a trial confirmation. I understand you still haven't picked up discovery for your case, though. What's going on?
Yeah, I just now got a phone that is actually mine. So, and like I said, I've been homeless because the no contact order. So it's been a struggle, so I'll make sure to pick it up as soon as possible, as soon as I can get a ride down there.
Okay. So I want to just rehash with you here. So you're representing yourself pro se. One of the benefits of having an attorney, and I believe from the docket notes here, you qualified for court-appointed counsel. One of the benefits there is it's not on you to pick up discovery and go through all of that. You have an attorney who's doing that for you. Are you still wishing to proceed without an attorney?
Yes, Your Honor.
Okay. All right. Do you understand that today, we could just set this case for trial. You've got trial dates, but you don't have discovery. And this point, if it would be continued, it would because, you didn't go out and get the discovery, and that's kind of on you. I understand you've got some hardships there, but again, that's why you have attorneys. So it's not a terribly powerful reason to not have the trial, as it's scheduled. Does any of that at all encourage you to talk to a lawyer?
I'd rather just continue to represent myself. I trust my own opinion and my own I just know that I have my own best interest at stake,
Hey, Miss Martini, we can't hear you again.
I trust myself. I don't really trust any court appointed attorneys, honestly.
Okay.
Yeah.
Well, we're here for trial confirmation. We've got trial dates, looks like towards the end of January. Are you ready for trial?
Well, I could be.
Okay, so I'm just
I
gonna.
have my side of the discovery, my evidence, and all my documents.
Okay, but you don't have any of the prosecutor's evidence against you.
This is true, but I'm confident in my own documentation.
Your Honor, is the court allowed to appoint a backup
Standby.
attorney or something that would be useful in this case?
We do.
I would like to have the prosecutor discovery as well.
Well, it's been available for you.
It's been available for over a month.
Yeah, and there was a court order for you to go pick that up. Yeah, but that's going to have to be on you to come get it.
Okay, and where do I pick that up at again?
You said it was at.
It was at Maine for a month and she knew that it was there.
It's at. So over at Superior Court, you said.
Yeah.
So it's at Thurston County Superior Court. It's been there for a month.
Okay. All right, I will make it over there to get it. Is that my discovery for all my cases, or is that just the district court, or?
That for all her district court cases.
2 DB cases.
Or you've got 2 domestic violence cases where the state has discovery. You've also got another case that's driving with a suspended license in the 3rd degree and driving without an ignition interlock device.
And that's the discovery for all of them?
No.
That's discovery for the 2 domestic violence cases.
Okay, can you also include the discovery for the other case?
Well, you're going to have to. Are you the attorney on those 2?
I'm not. And the state is getting a little frustrated
Yeah.
because we've had this sitting there and the court ordered her to get it by a certain date and she didn't.
Right.
I was not aware that it was a court order to go pick it up.
Well, I didn't issue that order. I mean,
Yeah.
whether or not it's a court order or not, I mean, it was there for you. So, okay.
Yeah, honestly, I don't even remember having that conversation. I remember them saying that they would get it ready, but like I said, I haven't had a phone, so maybe that was sent to my old phone number or something.
It wasn't.
I think it was sent. I think it was. It was said to you at the last hearing, so it wouldn't have gone to your phone. All right.
Okay.
She also received a letter at the Maine post office.
Okay.
She received notice in court multiple times.
All right. So jury trial dates are as currently set for on, you've got a case ending in 1017. That's assault in the 4th degree domestic violence. That's set for January 12th, so Monday. That's also when you're driving with a suspended license case is also set for trial on the 12th. And then on January 26th and 27th, that's your trial for protection order violation. All right. It looks like your speedy trial expiration time for the assault case, I believe, is January 18th. From the discussion that I heard earlier, I'm guessing that Monday the 12th.
Well, I mean, that's my concern.
Yeah. Yeah. All right. Let's see.
I mean, potentially.
Standby counsel. Public defenders. We done that for our cases yet? You're not on standby?
No, I think there was actually some discussion that she didn't want it at one of the hearings, that was imposed, and then Miss Martini got a little upset. But I don't know if that's something the court can actually force.
No, I don't think so.
Okay. Is she confirming for trial for the 12th?
Looking at her. So, okay, so the matter set on the 12th was, well, I'm not going to make a motion for you. So Ms. Martini, are you ready to go to trial on Monday?
Wait, I can try to be.
Okay, because if you confirm for trial on Monday, the prosecutor's showing up ready to go to trial. And if you show up and you're not ready, that's you're gonna have to be ready to go. I don't know what else to tell you.
No, well, okay, so this is just a confirmation for trial?
Yep.
So it's just gonna remain on the 12th, is that what you're saying?
Yeah, I mean, you haven't asked for a continuance. I haven't granted a continuance, but it's set for trial on Monday, and today's hearing is to confirm ready for trial.
And a continuance, how long would a continuance be?
Well, not very long. I mean, the only reason it would be continued is because you're not picking up discovery. And the only reason I'm inclined to maybe grant you one is I don't see that your case has been continued yet. And it's pretty often that people, get a continuance or so, one or two, but that's often when, attorneys and folks are working in good faith to try to resolve a matter, not just, not picking up discovery. So, I'll give you a continuance, not very long, but you need to actually ask for one too. I'm not going to continue it for you.
Okay. So I just ask for a continuance?
All right. Well, that's just going to be on the matter set for Monday. All right. So here's what I'm going to do. Miss Martini.
Yeah.
I'm going to continue. I'm going to find good cause. I recognize you're pro se, even though you're kind of pro se by choice here. Give you a good cause continuance for not being ready for trial on Monday in your assault case and the driving with suspended license and driving without ignition interlock case. Those are the two cases that are set for trial on Monday.
Okay.
But you also have trial, like I said, trial set for Monday, January 26th on the protection order violation. That is going to continue to be a trial date.
Okay.
What I'm going to do is that Monday morning, that's going to be your trial on the protection order case. I'm going to set that court date also for trial confirmation.
Okay.
For your assault case and the driving cases.
Okay, help me out here. Slow down.
Okay.
So till January 26th would be jury. So no change in 1023. The
So
protection.
1023, you're confirming, she's confirming
Yeah.
the trial?
Well, I guess.
Is that what you just did?
Well, I guess I should clarify that with her. So Ms. Martini, we're here also for trial confirmation on that protection order case on January 26th. Okay. All right. You haven't picked up discovery for that either. Okay. But we're here for trial confirmation on that as well.
That's plenty of time.
Okay. All right. So that's going to go to trial on Monday, the 26th. If you haven't picked up discovery by then, that's going to trial.
Yeah.
All right. So that's January 26th and 27th. So then also on January 26th, that will be trial confirmation so I'll do a good cause excluded period on 1017 and 6853 excluded period.
Text update.
Yep. One second, Ms. Martini. We're setting dates real quick. All right. Okay. So then so January 26th, that's going to be your trial on the protection order case. That is also going to be trial confirmation for the cases that would be going to trial on Monday. That's the assault case and the driving case. So that you have to come ready to confirm ready for trial on those cases, which means you need to have had the discovery and look through the discovery and be ready for trial. All right. For those, then your trial is going to be set for the following Monday, February 2nd and 3rd.
Okay.
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 All right. So your question about text reminders, you want the number you're calling in now to be the number where the court sends you text reminders?
Yes, please.
All right. Actually, does that all make sense? Okay. Ms. Pritikin, does that make sense?
Yes, thank you.
Okay.
Appreciate it.
All right. So Ms. Martini, again, Monday's cases are canceled. Your next court date's January 26th. Discovery for the domestic violence cases is waiting for you to pick it up at the courthouse. That's Thurston County Superior. Okay?
Okay.
All right.
Okay. Thank you, Your Honor.
All right. You're welcome. And you got to be there in person.
Am I done?
You are. You're free to go.
Okay, thank you.
What's your name, sir?
The principal name is Joseph Montez Logan. I'm an agent on behalf of the principal.
I'm sorry, say it one more time.
I got a doable power of attorney filed in Wayne County Register of Deeds. The principal name is Joseph Montez Logan. I'm an agent on behalf of the principal.
Okay, you're Joseph Montez Logan
Yes,
or Logan?
Yeah, that's my principal. Yes, ma'am.
That's your name. Sir, I'm Magistrate Echartea. You're here on a criminal matter. 250-453-2601. You have an attorney. Go ahead, counsel. Counsel Reagan, you wait for a reading. Stand mute.
Judge, he's representing himself. He's the principal or the agent of the principal attorney of himself. He's representing himself.
Okay. So, Mr. Logan, you want to waive the formal reading, or do you want me to read the charges?
I would like to see the discovery first and the nature of the cause.
Okay, the discovery, that comes after, sir. Okay, this is only an arraignment. So my question is do you want me to read the charges to you or not?
Yes, ma'am. I'd like to hear the reading.
Okay. So, sir, people of the state of Michigan versus Joseph Montez Logan, allegedly on May 15, 2025, in the area of 18637 Albion Street, City of Detroit, did commit count 1, domestic violence, did make an assault or assault and battery upon a Tanisha Logan, a resident or former resident of his or her household, and or an individual with whom he has a child in common, and or his spouse, contrary to the MCL 750.812. Okay, maximum penalty is up to 93 days jail and or $500 fine. Do you understand that, sir?
No, ma'am. I do not understand that.
You do not?
At the moment,
what is it that you do not understand?
Well, because MCL 12.280 gives you the personal liability of my agent capacity, and that gives you understanding of 1 and 2, saying that I have the same rights as a self-appointed a state appointee, the same rights as a state appointee, and I have no interest in this matter.
Okay, well, sir, you are the individual. I'm going to enter a plea of not guilty. It alleges that you did make an assault and battery on a Tanisha Logan. Okay. Again, the penalty is up to 93 days jail and or $500 fine. I'm going to enter a plea of not guilty. Let me give you your court date, sir, which is going to be May 28, 2025, free trial. It's an in-person hearing. Let me make sure. 8:30 in person here at 36th District Court in front of Judge Austin Garrett. Do you understand that, sir?
No, ma'am.
No, I don't think that. I think you do understand, sir, because by your talking, okay, you do understand English. Whether or not you disagree with it, sir, that's another matter, Mr. Logan. But everything is placed on the record because everything is being recorded, sir. But I do believe you understand English. I'm giving you that court date. I'm also letting you know, sir, in terms of whether or not you wish to go forward, however it is, that's going to go in front of Judge Austin Garrett. Do you understand that?
No, ma'am. I do not understand any of the matter, any of the charges, none of what you're saying, because I'm actually the agent on behalf of the principal.
Okay.
No well, in this case, and you try to build a case on me personally, and I'm not liable. I don't have an interest in this matter.
Okay. Thank you, Mr. Logan, but you place that on the record. No. I've heard that. Sir, you still have that court date. I gave it to you. Okay. If you do not show up, a warrant will go out for your arrest. As to whether or not, like I said, when you want to argue as to motions or not, that's going to be between you and Judge Garrett. Okay. Let me give you some bond conditions, sir. That means you need to abide. You're not to have contact with a Tanisha Logan. That means no person-to-person contact. No contact to third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go back to the no, that's your residence. So I'm not putting that on. Just no contact and no firearms. You understand that?
That was with the minor children involved.
The minor children, that, let me see. As to the minor children, sir, okay, that's up to family court. So I'm not dealing with the minor children.
So there's no stipulations?
Those two conditions, okay? I don't see anything to indicate that these children are subject of this case. So do you understand what I've just said, everything so far?
Ma'am, I do not understand, but I will take your ruling on behalf of the principal. I can only do what I can.
Okay, no problem. Okay, this allegedly happened at your residence, sir. I also see in this particular matter, there was no injuries. The complaint declined medical attention. Let me see what else.
I got a question, ma'am. Is she moving forward with the case?
Hold on. Okay. There was a 2016 domestic violence misdemeanor. I don't have anything else. What's your question, sir?
Is Tanisha Logan moving forward with the case?
Is she a what?
She's pressing charges, Tanisha Logan.
Okay. So you understand, Mr. Logan, okay? It is not up to the complainant to press charges. Charges come from the county, the prosecutor's office.
Oh, okay. Well, I'm just of the understanding that the state of Michigan is a legal fiction. It's not a living person.
Okay. It's the state of Michigan. That's why I read the state of Michigan, or the people of the state of Michigan versus you, sir. So okay. It is up to the prosecutor's office that files the charges. They have filed the charges. Whatever happens after that, that's going to occur in front of Judge Austin Garrett, his courtroom. So I see that you have local ties. Anything else you want to add, sir?
No, not at the moment. No,
okay. Well, this is going to be it, sir. In this case, bond is going to be $25,000 personal bond. Nobody has to pay any money for you to get out of jail. I will caution you, sir, that you have no contact with the complainant. Even if the complainant wants to talk to you, you cannot, because you're under court order. Now, you can take all those issues up with Judge Austin Garrett on your court date of May 28th. Do you understand that, sir?
I was able to understand that this was a misdemeanor charge and not a criminal charge. So I don't understand how.
No, it is a criminal charge. Anytime when you can go to jail, you can be incarcerated, it is a criminal charge.
Yes, that's crazy. Okay, well, I'll just fight it in court.
So, $25,000 personal bond. Good luck, sir. You can step aside.
Well, guys, we have come to the end of the proceeding for Mr. Joseph Logan. As we can see, he is facing a serious charge, and it seems like he's had this charge in the past, according to Magistrate Echartea. He kept saying he doesn't understand, as if that was going to make the case go away. But then on the other hand, he confirms that the incident took place. One thing you notice in mostly all states is that anytime a domestic violence charge or an accusation goes forth, somebody's arrested for it, a lot of times it's no longer up to the victim to press charges, because the state takes it over for many different reasons. We've had people where they've gotten in domestic violence situations, recanted, said, listen, I don't want them to get in trouble, and unfortunately have lost their lives, so on and so forth. So most states, they don't play that. They take control of the case. They get involved. It's no longer up to the victim. Now you got to fight it in court against us and prove whether the victim is lying or not lying, if it happened or didn't happen. And that's what we've seen in this case. We see Magistrate Echartea be very adamant with Mr. Logan about staying away from the victim. Will he do that? Who knows? But many men and women have gotten in a lot of trouble by, crossing those boundaries, those what do you call it? The protective orders and stuff like that, like just not respecting them. And nowadays they take those things very serious. So hopefully he does the right thing. Hopefully if he did put his hands on this young lady, he doesn't do it again. But May 28th, we will follow up with this case and see what happens. And with that being said, guys, thank you always for joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, subscribe, and share. And for now, guys, Sovereign Citizens Court is adjourned. I appreciate you guys. Catch you on the next one. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.